So I want to talk to you about how effective your SAGES staff is and how bad the technology in my hospital is because this talk got moved to tomorrow on my calendar, and I was happily having lunch at 2 o'clock when the SAGES staff tracked me down, loaded my video, and got me into the room 20 minutes early. So my apologies to any heartache that I caused the panel chairs in my own stupidity. So I feel like I'm the wet blanket after all this exciting technology, and I'm the bad guy that's going to tell you, what you can and can't put on, and why do I know anything about HIPAA? I had the fortune or misfortune to be the head of the IRB at Tufts when HIPAA hit and had to learn everything about HIPAA for research. And as we were going through massive institutional change when the privacy rule took place, I met a group of hospital attorneys and we said, gee, we should really look at what the impact is on multimedia presentations, because people were talking about, like, we can't put an x-ray up, we'll never put a video up, you can't put a picture up. And so we formed a small group and went through the law, and we published this in Surgical Endoscopy in 2005, and this is the sort of the reference material, because it hasn't changed for this talk. So why did the privacy rule come about? And the answer is, with the digital age came intended and unintended consequences. And amongst the unintended consequences was the safety of our information that used to sit in analog fashion in hospital medical records, because just try stealing 10,000 medical records. I mean, can you imagine a guy walking out the door with truckloads of charts? That would be pretty hard to do compared to downloading 30,000 records, 50,000 records, 100,000 records on your flash drive. The information age has brought new wonders, new challenges, and new problems. And amongst that information that was now transmittable was visual information as well. So all of this got rolled in. So the question is, why did we actually need a privacy rule? And we keep on referring this to HIPAA, but HIPAA is a big law, and it has more to do with protecting your health insurance when you change jobs than privacy. Privacy rule is just one aspect of HIPAA. So when you want to refer to it correctly, you say, well, HIPAA says this, HIPAA says that. Well, often people are wrong, and it's only the privacy rule that they're talking about. And prior to the HIPAA privacy rule, patient protection and confidentiality was really a series of fragmented patchworks, and although I came to hate it while I was working with it, there are some good points to all this that we should be thankful for as well. Once this information moves electronically to, say, your health plan, nothing prior to the HIPAA privacy rule prevented your health plan from selling this information back to your job, to your employers. And there are people with medical conditions who might be deemed undesirable in terms of employment. So there's really a lot of protections that are afforded because, unlike paper, which is hard to move, electronic records can be moved en masse, again, in the blink of an eye, without anybody telling you that this stuff is moving. So one of the things that I appreciated in the privacy rule is there were more than one game changer. And one of the other game changers was the Human Genome Project, and why having all this electronic information and protecting it is very important. So it used to be that if you had tissue in a tissue bank and it was de-identified, that was great. And as a glass slide, and you could use it for research and do whatever you want, they could never get back to you until the Human Genome Project. And countries like Iceland started doing genotyping on every single person in the country. So if you live in Iceland and somebody has a piece of tissue, somebody could take tissue taken out of your body with no identifiers, no tags, no nothing, and take it all the way back to you. Do you think that's important? Well, maybe. And if you want a dystopic view of how this might be bad for you, think of Gattaca. But also think of employers in large institutions. So the privacy rule is not all bad. So let's talk about multimedia. In order to understand the HIPAA privacy rule, you need to have definitions that we can all work with in common. The first one is PHI, Protected Health Information. And that's medical information created in an electronic record. That's PHI. PHI is used in something known as the covered entity, and we'll show how this works and why it's relevant to you. Covered entities include health plans, healthcare clearinghouses, providers, anybody who transmits protected health information electronically. One of the great jokes was if you were completely on paper, you were completely free of HIPAA privacy rule requirements, although nobody can get paid if you're only on paper these days. The next term that you have to understand is the word use. Information in the HIPAA world, the privacy rule world, is used. It's used within the covered entity, and there are acceptable and unacceptable uses. And when it leaves the covered entity, it's not used, it's disclosed. So those are some of the key terms, and how can we make this? So in the HIPAA world, it's all about the identifiers, and there are 18 identifiers that are used in HIPAA. And the bad news is that not only are these 18 relevant, but if you put them in combinations, things that were not relevant become relevant. So they can be used individually or in combinations, and so you have to watch how your multimedia and other types of information is used together. So I highlighted full face photography and images or any comparable images, but if you put an image with a name, now it's the image's protected health information. So let's go through some settings where, protected health information can be used inside the covered entity. So what is the covered entity? It's your hospital, it's your practice, and there's a lot of legal paper that goes around in the background that describes it, so we'll go through this. So what about a peer-protected morbidity and mortality conference? Can you have multimedia information, videos that you might make for the conference, with the patient's name, face, et cetera, on it? And the answer is yes. Identifiable PHI may be shown, that's a use, for educational and quality purposes within the covered entity. So if you're doing M&M and you happen to be a facial surgeon and you want to show the results of your plastic surgery, as long as you're inside the covered entity, you can show the patient's face without any authorization from the patient. It's a legitimate use inside of the covered entity. Let's try another one. At grand rounds in your home hospital, can you show the face and the name of a patient? I go to these grand rounds, it's kind of fun, being invited to give visiting professors, and you see this stuff and a lot of initials and this and that. But in your home hospital, once again, at grand rounds in your home hospital, you can use identifiable multimedia information and other information as long as it's shown for education and quality purposes inside of the covered entity. So that's good to know. So let's make it a little more complicated. What if medical students are present? And medical students might be from your university, they might be from the hospital across town rotating over, but I assure you there are legal HIPAA agreements called BAs, Business Associate Agreements, that occur between all of these institutions. So they're happening in the background. And thus medical students are considered part of the covered entity's workforce and thus have access to PHI, protected health information, as do other staff. So just because it's not a hospital employee, if it's a member of the covered entity's workforce, such as a medical student, you can show the face and the name and everything else. Well, let's change it up a little bit more. Some of these educational activities, at least in the past, used to be sponsored by pharmaceuticals and device reps who enjoyed sitting in and learning something, a legitimate learning activity. No sales involved, sit quietly in the back of the room, this and that, except for in Massachusetts where they can't bring you any food. If pharmaceutical and device reps are present, they are not part of the workforce. And if so, if your grand rounds, if your multimedia presentation includes PHI, and there are people outside of the covered entity, out of their workforce, then PHI should not be shared or discussed unless they specifically have a BA in place. So if for some reason there was a BA between that division of the workforce and that company, then you could show it. But in general, they don't, so you can't. So let's think about outside of the covered entity, of what you can show. What if you are having your grand rounds, like you do every week, but this week you have an outside visiting professor, And he's got a slide set from his grand rounds that he gave last month in his own hospital. In that case, that same presentation given outside of his home hospital must be de-identified. That means none of those 18 identifiers may be allowed, because when that ground run speaker comes to your hospital, you have no relationship with the speaker or the original hospital. And therefore, he may not use or disclose protected health information in your hospital, and thus it must be de-identified. I want to go back for 1 second. So we talked about all this protected information, and one of the rules that applies is something called the minimum necessary rule. When you disclose protected health information, you are obligated to do your best, whatever that means, to just use the least amount of identifiers possible. So if you don't need identifiers, then you should take them out, according to the minimum necessary rule. All right, so we're giving gang round only de-identified data. What if I come to SAGES and I use that same talk, really getting a lot of mileage out of the talk I made? It's the same rules. De-identified data may be presented. I can show pictures, I can show videos, I can show x-rays, I can show de-identified voice prints, as long as none of those 18 identifiers are used in combinations or singly that would identify the patient. Well, what if it's impossible? What if it's a plastic surgery meeting? And you have to show the face. Then, if you want to show it at a national meeting, you have to obtain written authorization to share and disclose the PHI. Now, many of us have patients, and they're all very nice, and they say, gee, you know, I really like the way your facelift turned out. You know, I'd like to be able to show it at a national meeting. You really look great. You look marvelous. And they go, yeah, sure, you can go ahead and show it. Verbal permission, even in the face of a witness, does not meet the written authorization test. You have to have written authorization indicating that you have the patient's permission for the intended use of that material, and we'll see how that works. What if you're in a state where you still have a drug or device dinner, and it's a device dinner of plastic surgeons, and they show a lot of facial work, and that patient gave you written authorization to show it at the plastic surgery national meeting for educational purposes? Is that good enough? And the answer is no. Not only should it be de-identified, but if you can't, you need written authorization, including in this last example, that it is going to be specifically used in a marketing setting. So the nature and purpose of the protected health information, when it's used outside of the covered entity, has to be specified. So you can do it, and you can get it, but you have to have a written authorization. And this is very similar to, hey, my friend asked me to look something up in the medical record, is that okay? And the answer is sure if you have a written authorization, but not without. Other questions that relate, to what we're talking about today. I would like to record all or part of my laparoscopic surgery and use it for whatever. Can I do that? And the answer is most hospitals, in their hospital consent, have a small section of authorization because, and we'll go through this again, consents are clinical and HIPAAs are authorizations, that allow people to create videos and pictures as part of the surgery. Now, here's the kicker, and this is the part you have to pay attention to. If PHI is attached, and an example of that would be the sticker. If PHI is attached, that DVD with the sticker on it is actually part of the medical record. You're sitting with a piece of the chart on your desk, and you are now obligated by all the rules and privacy concerns that are spelled out in the privacy legislature. You're a little mini medical records. Well, it's my patient, it's my surgery. That's great. It's also your little medical records room sitting on your desk. But if you do one simple thing, and that's take the sticker off, and it's just another gallbladder, and there's no more date information, Date is an identifier, particularly date of surgery. There's no name information. And if it's nothing so dramatic, and we'll talk about dramatic, if it's nothing so dramatic that you could honestly say, that's Mrs. Jones, then you now are sitting on a big pile of de-identified data that you can bring to national meetings, take to a drug and device dinner, show at your grand rounds because you'd be allowed even if it had the PHI. And so what I'm telling you is if you're sitting on a stack of CDs and DVDs with patient stickers on them, take them off. Not only that, it's discoverable. Now, many people put images in the medical record, and people, if you have Epic or something like that, you can put video in. And so you may want to leave the sticker on until you decide how you're going to use it in the record, and then take the sticker off and stick it in your education pile. Because you don't want to take a chance you stick it on the wrong chart. So it's a use while you're putting it in the medical record, and then it becomes de-identified when you're finished with that task and use it for education. Take the stickers off, and then you're not sitting on PHI. So here's another classic example in the time remaining. You show this x-ray at a colorectal meeting, and a person in the crowd shouts, "You're using my x-ray without my permission. I'm going to sue you." Now, first of all, if that were my x-ray, I'm not sure I'm raising my hand. Let's just be serious here. But if you were so inclined, whether you were right or wrong, does the patient have a leg to stand on? And the answer is no. This x-ray is sufficiently de-identified until you raised your hand, which is not the surgeon's problem, that there are no HIPAA violations, nor does this piece of medical record engender property rights. So this issue of going back to things like HeLa cells, who owns the HeLa cells and the cancer lines, this is very different. If you use a x-ray in an educational talk for which it is legitimately de-identified, then the patient has no property rights to the image, even though it's an image to them. You are in the clear. What about expectations? What do we expect from you when you show this? As the editor for video for surgical endoscopy, I get videos all the time with names on it, and I have to send it back, and it's not adequately de-identified. And one of the things I do when I'm reviewing the videos is make sure that they're adequately de-identified. So this is not uncommon. This is a CAT scan, and this, showing information like this just wouldn't cut it. We expect something more like this. And I don't want to go overly technical, but this is easy in Photoshop, and you just take the black eraser and you take it off. Or you get smart about how you capture the image to begin with. And you can make similar types of transformations. I'm personally, as many of you know, Dan Heron and I put on many surgeon in the digital aids teaching people to edit video, and you can use some of the titling and some of the other black screens to do it. You can create truly de-identified images. But there are some special cases. And so I'm going to just put it to you. Here is a screenshot from my medical record. And you can see it's got lots of stuff on here. I'll ask for a show of hands. How many people think this would be a HIPAA violation, showing everything including the patient's name at this meeting? Is it definitely a HIPAA violation? Are you certain it's a HIPAA violation? Okay, keep your hand up if you're certain it's a HIPAA violation. What if I told you the patient was dead? How many people think it's a HIPAA violation? Dead patients have no status in HIPAA. Now, here's the thing. There are common privacy considerations. So the smart thing to do is take the patient's name off it anyway. But it's not a HIPAA violation to show PHI from a deceased patient. It may be a common sense violation, but it's not a HIPAA violation because deceased patients have no status. So last example, how many identifiers are being shown here? How many think there are no identifiers in this picture? How many think there's one identifier in the picture? How many think there are two identifiers in the picture? If you said two, you would be right because this patient has progeria. And this disease is so rare, each individual patient is unique and therefore can't be adequately de-identified, even if you say there's a progeria patient in the Northeast, because the disease is so rare. This is off the internet, so it's already out there in the public domain. This is technically 2 identifiers, progeria and the name, face, and very rare disease. So finally, my last slide is, when you think HIPAA, clinical requires consent. HIPAA requires written authorizations. Thank you very much.